I would like to welcome you to the Court of Common Pleas General Division, our court and community working together. My name is Napoleon Bell, and I'm the Director of Diversity, Equity, and Inclusion at the court. So we are so happy to see all of you here to be a part of this conversation that we are having here today with our esteemed judges and also our administrators that are here with us also, and we will introduce all of them here in just a moment. But first, let me just give you some ground rules in a sense. When you want to ask a question, we have cards that our HR director there has cards in her hand. If you need a card that she says, hey, I want to ask a question, just raise your hand to her. She'll get you the card, and then you just fill out the card with the question that you have. And then our other representative you just raise your hand and says, hey, I've got my question, and she'll grab the card so that I can make sure that I ask those questions, all right? And then I'll get the cards will be brought up to me, okay? We're good with that? All right, and then secondly, I know that sometimes folk will come and they're like, my case was such and such, and I need to know about that, right? We're not here for that. We can't try your case here at the Court and Community Together. So really, why the judges are here and why the administration is here to really let you know about the roles and responsibilities of the courts, how it functions, and what the goals are here with the court. So and then also talk about some of the specialty dockets that are here available at the court that are helping people throughout Franklin County. So if we're good with that, I would like to go ahead and get started. And I will quickly just go down the line and introduce our judges and the administrators that are here, and then we'll get started with the conversation. So, to my immediate left, we have Judge Jiza Page. Next to her, we have Judge Andy Miller. Next to her, we have Judge Stephen McIntosh. Next to her, we have next to him, Judge Karen Phipps. And then next to her, we have Judge Cheryl Munson. And then on down you can give them a round of applause. Yeah, it's okay. All right. We're good. And then next to the judges, we have our court administrator, Jen Goodman. We have our chief probation officer, Dan Wunderlich. And next to him, we have our chief IT, but our director of IT, Andrew Byerly. And then as we spoke also over here, we have our human resource director, Cameo Davis. So please give all of them a round of welcome. All right, so we'll go ahead and get started with the conversation. But first, what I'd like to do is give the judges an opportunity to, first of all, tell us, who they are, but just a little bit about themselves. We feel as though it's important, right? That's why we're here, is to get to know the judges and to understand the judge behind the rope. So if we could start with my left with Judge Page and just tell us just a little bit about yourself, and then we'll just pass the mic down as we go. Judge Page.
Thank you, Director Bell.
There you go.
Thank you, Dr. Bell. Good evening, everyone. My name is Jiza Page, and as stated, I am one of 17 judges of the Franklin County Court of Common Pleas General Division. I am a Columbus girl, born and raised here. Live primarily on the northeast side, Linden community, until I was about 16. Then my mom moved us to the east side of Columbus. I knew since I was 8 that I wanted to be an attorney. Have had great mentors in the legal community here in Columbus who have really helped me kind of forge my path. I ran for a judge in 2018, was successfully elected, and I've been serving since then. And thank you so much for having us this evening.
Good evening. I'm Judge Andy Miller, also a judge on the Franklin County Court of Common Pleas General Division. I am a Dayton boy, born and raised north of Dayton, Englewood, Ohio, went to Northmont City Schools. Became a judge in 2020 or 2021. I ran in 2020, but I had a kind of a long winding road there. After law school, which was at Ohio State, way back when, I did a couple federal clerkships, one for a federal appellate judge in Texas, another for a federal district judge in Los Angeles. I then came back to Columbus, worked at a large firm here for a while, then left again, the state of Ohio, went down south and taught law, first in New Orleans, then in Houston. My wife and I, we became pregnant with our first child. I decided I missed the courtroom, and we all missed Ohio, so we decided to come back. I was lucky enough at the time to have my resume cross Rick Pfeiffer's desk. He was the Columbus City attorney at the time. And so I basically, for the about 11 to 12 years prior to being on the bench, I was an assistant city attorney with the city of Columbus in their civil litigation section.
Good evening, everyone. My name is Stephen McIntosh. I am now in my 21st year on the bench, so I've been on the bench since 2007. And hopefully we'll have an opportunity for me to discuss a lot of the changes that I've had the opportunity to observe in the court system during the time that I've been there. But I am originally from Columbia, South Carolina. Came to Ohio to go to law school at Ohio State. After graduating Ohio State, I always say the reason that I'm here in Ohio is because I got a job and a wife. And so it's because of those reasons that I'm still here. And actually, my wife is here. But I have had the opportunity, when I was in law school, I found out that what I wanted to do was litigation and be in a courtroom. And I've had the opportunity to do that throughout my career, from both as a prosecutor, I was the chief prosecutor for the city of Columbus, but also worked for a firm where I did criminal defense work representing people charged with crimes as well. So I was able to do criminal, civil from both plaintiff defendant side also. So had a pretty decent sense of all aspects of the law when I was able to get on the bench and have found my experience extremely rewarding. And hopefully, again, we'll get into a little bit more, helping you understand a lot of the things that we're doing now.
Good evening, everybody. It's great to see so many people out here and interested. I have been on the bench. I actually ran with Judge Page, but I'll tell you a little bit about my backstory, because part of what I think makes me a really good judge is my backstory. So I was raised in Wisconsin. My dad was an immigrant. He came across on a boat with his 6 siblings when he was 5 with his parents in between the world wars. They got sent from Ellis Island to Wisconsin because that's where you sent people who were Dutch because they're used to cold weather. So I grew up there. My mom and dad had 16 children. I have 10 sisters and 5 brothers. And you didn't know that? And so what's important about that part of the story is, one, I was raised by an immigrant first, so technically I'm first generation on my father's side. Also, unfortunately, my dad passed when my mom still had 8 children at home, and she had never worked because women in those days didn't work. And so I know a little bit about struggle. I know a little bit about how hard it is to get on the right path when you're poor. But my mom did a great job. I didn't follow the path she wanted. I did not go to college right away. I got married. I had children. And then I ended up not being married. And I suddenly had to realize I have to do this because no one else is going to do it. And so I went back to school. I finished up my undergrad. When they were in school full time, I went to law school as a single mom, bartended my way through law school. Then I went to work for a firm, and I started working in a firm during law school. I worked at a defense firm, civil defense, then I went to plaintiff, and then I was not a traditional student. I had children at home. I had obligations. I needed a more flexible schedule. So I opened my own firm, and for 15 years, I defended people who were charged with crimes, and I loved it. And I really love litigation, and I got to a point in my career where I saw that changes needed to be made, and I believe you put up or you shut up. And so I decided I was going to run for judge, and I became a judge, and I'm doing the very best I can to help everybody who comes in front of me. I'm the administrative judge this year, so part of my vision for the court is that everybody who comes to court isn't afraid to come to court, and that they know that we want to hear them, whether they're a defendant or whether they're a victim or whether they're being sued. I want everyone to know that the courthouse is in a bad place and that you can be heard and you can have your day in court. And I don't know that the community understands that all of us feel that way. And seeing these fine young gentlemen here in the front, part of what we were all discussing before we started was how happy we are to see successful people. People often think judges really enjoy punishing. No, we do not. We want to help people. And so when we see success stories, that makes it all worth it. Every time we have a rough night sleeping because of something that happened, we just live off of the success of other people in our community.
Thank you. Cheryl Munson. I also am a judge on the Franklin County Court of Common Pleas General Division. Prior to becoming a judge, I was a Franklin County public defender for 26 years. I intended to live and die as a public defender. I was what they call a true believer in that mission. But in 2020, I did decide to run. At that time, though, we have amazing folks on the bench. We had no former public defenders on the bench, and I thought that was a very important perspective to bring, having exclusively worked with marginalized and underserved communities and understanding what those folks were facing when they came into the courthouse. So, born and raised in Marion, Ohio, first generation college student. No one in my family had gone to college before I went to college. Undergraduate at Ohio State Law School, where I started clerking again for the Public Defender's Office, and then was fortunate enough to run and be elected to this bench in 20 to an unexpired seat. So I did run again in 22. And just honored to sit next to these amazing folks that I practiced in front of, or with and in front of, and now sit next to them on the bench is a true honor. So, and thank you all again. As Judge Phipps said, we are public servants, right? We are elected to serve our community, and our community deserves to know what's happening in the courthouse. And so that's why we're here today, to honor that obligation we have to be transparent and available to you. So thank you for being here.
Thank you, judges, and I'd like to go back to talk with you, Judge Phipps. You mentioned that you're the administrative judge, and so what does that mean? What does the role of the administrative judge entail?
It entails helping the court administrators administer it. If we think of the courthouse as a business, I'm just going to make it simple because I could go into a lengthy legal discussion, but I'm going to make it simple. If the courthouse was a business, you need someone to help run the business. And as administrative judge, there's a lot of meetings, there's a lot of work that involves the behind the scenes and helping the court administrators do their job to help the court run successfully.
Okay. That's short and to the point. I appreciate that. So, but as administrator, are you the top judge?
No.
Okay, no. All right.
I am not I'm not the bosses of anyone here. I am just someone who helps facilitate. Everyone, all the judges are equal. The AJ, or administrative judge, is just a judge that takes on slightly more responsibility to help the court run successfully.
Okay. Now, is there a judge? Now, there's a presiding judge also, and
Correct. Do you want to explain it?
Well,
What
okay.
presiding
Well,
judge does?
You should also tell him how long you were.
Oh,
Wow.
yeah. Ask him questions about AJ.
The presiding judge, you heard us all say that we're the Court of Common Pleas General Division. So there's also under the Court of Common Pleas is the Juvenile Domestic Relations Court and the Probate Court. So the presiding judge is the judge that's kind of responsible for all of the courts. And thank goodness, for the most part, it's just ceremonial. But we have to have a presiding judge. And so in our court, the presiding judge is separate from the administrative judge. You may hear some courts have an AJPJ, but we separate the two. Now, I did have the pleasure of serving as the administrative judge as well for 6 years. And everything that Judge Phipps said is correct. I mean, you're really just managing the day-to-day of the court with all the different employees, with all the different divisions that we have within our court. It's extremely important. It would not make sense for all 17 judges to try to run the court. And so the judges elect someone, which we did. We elected Judge Phipps to be the one responsible for the day-to-day.
thank you, Judge. So, one of you mentioned the different courts. So we talk about municipal and domestic relations court, probate, juvenile. often, what we find is that, people don't understand the difference, right? Or, well, where am I at? Where's municipal? So it all runs together. Could someone explain kind of the differences between the courts?
So each one of the courts are created by legislative action and our Constitution. Now, the easiest way to explain it is the Court of Common Pleas, especially General Division, but the Court of Common Pleas is what we call the Court of General Jurisdiction. Basically, it means every case starts with us unless there's some statutory reason to send it to another court. That's the very technically correct term, but the way most people understand it, or the fastest way to explain it, is what comes to us are felonies and large lawsuits in excess of $15,000. However, if you have a lawsuit that's less than that, less than $15,000, a civil suit between parties, they will typically go to a municipal court or a county court because that's where the statute veers those disputes. Misdemeanors go to municipal court. Traffic violations can go to municipal court or to mayor's courts. The probate court, its jurisdiction is wills, trusts, estates, intestacy, divorce, death, certificates, and those things. Domestic relations and the juvenile relations, or domestic relations juvenile court is kind of self-explanatory in its name, but that's really how it works. Each one of these courts have a limited jurisdiction. We have what would be called general jurisdiction, but it's limited in that everything but large lawsuits and felonies typically go somewhere else. And that's probably the best way to explain it in a nutshell. It gets super complicated if you wanted me to talk for hours about it, but nobody wants that.
No, we don't have that much time, but thank you though, Judge, for offering, right? So with that being said, we think about the court and you're always, trials and all of that, but we also, there's also things that go in the court that are geared to help people through what they're dealing with and why they're there, which are particular courts that either deal with alcoholism, et cetera, et cetera. So let me first start off with with Judge Page with a new piece that I'm sure she'd like to talk about, which is the Pivot program.
Yes. In partnership with the Board of Commissioners, Kevin Boyce, and I also like to mention Director Stockton, who is here, who is the new Director of Justice Policy and Programs with Franklin County. We have started a pilot program that right now is just focused on my docket, and it's for those who are charged with F4s and F5s. Once they have their first trial date, we're trying to figure out if there are resources that can be provided to ensure that someone isn't picking up a second charge or more serious charge while they are awaiting trial on what is typically a low-level offense that most of the times the individual would get a period of probation. And so what I saw in my court, which I know it's the same with my colleagues, I'll just provide a particular example. There's a young lady, 18 years old. She was in a car with a guy. They get pulled over. There's a gun in the car. She gets charged with improper handling. She gets arrested. She gets a recognizance bond. She's out. Maybe a month later, same thing happens. So from the first offense, nothing changed in her life. She's still hanging out with the same people. She was not in school. Her home life hadn't changed. And so now she's facing 2 felony charges versus just 1. And so I think, what can we do as a justice system to try to step in earlier and ensure that, to the best of our ability, people are making their court dates, because when you get a capias, we know what happens, you get arrested, and so then there's a period of incarceration. And also to try to give them the tools that they need to correct any criminal behaviors. We are currently in our first cohort. Right now, everyone's doing well. Everyone has made all their court dates, and no one has any new felony offenses. So I would say we're at 100% rate right now, but it's been since February. So, but that is something that it's been exciting so far, and we're looking forward to just see how it can grow.
All right. Thank you so much, Judge Page. So moving over to Judge Miller. So you've always been partnering with with the Justice for All summer camp and making all that happen. Tell us a little bit about that.
All right, well, the Justice for All Summer Camp is actually, I want to say, the brainchild of Judge Page and former judge, now Justice Dan Hawkins. And I believe it's 6 years now? All right, so it'll be in its 6th year this year. This will be my 3rd year with it. Once Judge Hawkins left the bench and moved on, I slided into the place because I love the program. But essentially what it is, it's law summer camp for upcoming 8th graders through 12th graders. We hold it in conjunction with the Ohio State University College of Law, and basically we bring the kids in and we teach them about the justice system, law, legal reasoning and analysis. Some of it's basic trivia about how the court system works. Some of it is walking them through the legal analysis. I have a couple, what I call, sort of truncated law review or like law school classes where I actually engage a Socratic method like they would see in law school. It culminates with a mock trial that the students participate in, and that takes place down at our courthouse. This year we've expanded for a 2nd week, and that 2nd week is to serve those students with disabilities. So this is going to be new, and I really wish I could speak more intelligently about what that's going to look like, but we're kind of figuring that out right now as we approach. It happens in June. But it's free to any students when they apply. There's an application process. We review those applications and admit, how many total? 60 to 75. Wow. But it's a great program because it's an opportunity to hear, not only to teach students these are the basics, this is what, but to also hear what they and their peers think. What is the word out there? What is the common knowledge? What do you think the court does? And it becomes an excellent barometer for us to understand where misunderstandings may be coming from, how to correct those. And it's in addition to the obvious fun part of teaching the law, doing the fun summer camp stuff. But it is an excellent way for us to hear what the public out there thinks about the generalized court system, where gaps in maybe the community's knowledge is about what we do and how it works. But all in all, it's tremendous to watch. We have a couple repeat campers now, and you can kind of see them. You can see them now. I mean, I know they're going to be in 5 or 6 years lawyers themselves. Well, 5 or 6, but 10 years. They'll be lawyers themselves. But yeah, you can almost tell some of the kids that we've seen as repeat, they're hungry, they come back again. They're going to be monsters in law school.
Yeah. Now, are you still taking applications on that?
Applications closed
Closed
on
out?
the 31st
Okay.
of
All
March.
right.
Yeah. So
Shucks. Well,
next year.
Next year, right? All right. Thank you so much, Judge. Well, moving down the line, while we're going down the list here, a program that I've seen that many graduations and that is headed up by Judge McIntosh, which is the TIES program. And please let our viewing audience know a little bit more about the TIES program.
Okay. Thank you. TIES stands for Treatment is Essential to Success, and it's a drug treatment program. As I indicated to you, when I first started on the bench, we really did not have specialty dockets. It really was very much you sentence someone and you send them on their way and you hope for the best. And I was really pleased over the course of the time that I've been on the bench that we as a court system, and I think you too as a community, have come to the realization that we need to do more than just either send someone to prison or send them back into the community and hope for the best. TIES is one example of that. It's a drug treatment court in which if a person gets accepted into the court in phase 1 of the program, I see them every week. Now, generally speaking, if someone's on my regular docket and I sentence them on a drug case, I may not see them again. But these are individuals that the other judges have recognized, or persons in the probation department have recognized that their needs are greater than what we can just provide them on regular probation. These are individuals, many of whom have been in and out of prison, in and out of treatment programs, And so the program is intense to provide them the level of structure that they would not routinely get. So like I said, individuals in phase 1 of the program, I see them every week. They're all linked to different agencies throughout the community for drug treatment programs. If they're in the first phase of the program, 9 times out of 10, they're either doing intensive outpatient, which means that they are in counseling at least 3 days a week, meeting with, or in group 3 days a week, meeting with the counselor at least once a week. We require them to do at least 3 random screens a week. They're required to attend at least 3 AA/NA meetings per week. And then when I see them, I get a report from their community agency to see, okay, John Smith has reported this week, he's engaged in treatment, he's dropped negative. And the main purpose, I think, for my role is to provide guidance. Look, Mr. Smith, okay, what's happening? What's going on? Why are you missing these programs? What's happening? So that we as a treatment team can figure out what their needs are and try to tailor something that works for them. But I think also the greatest part of my role is, Mr. Smith, you're doing a great job. I'm encouraging them. I'm letting them know that the court sees them and that they are actually doing things in a way that provides them some hope for the future. One of the first things that hit me when I got on the bench was the needs of the individuals that come in front of us every day are so great. I mean, yes, we deal with people that probably do deserve to go to prison, but we deal with a lot of people. It really is about trying to help them figure out what they need. What is that drug treatment, with the mental health treatment, employment skills that they need, so that we can return them to the community so that they can be productive and self-sufficient. And I don't want to take too much more time, but the greatest thing about the program is seeing people who can successfully complete the TIES program. Generally speaking, if you do everything perfectly, it's still going to take you about 1.5 years to get through the program, because it's our goal by the time they get to the end of the program. If they didn't have custody of their children, now they have custody of their children. If they didn't have a job, now they are working and able to sustain themselves. I've had so many people tell me, Judge, this is the first time I've had a bank account. Judge, this is the first time that I've been able to buy a car on my own. Judge, this is the first time that I had a job that if I didn't go to work, I still get paid. And so our goal is, once they successfully complete the program, they have all the tools and the skills that they need to be successful in the community. And it really is. So many people that make it to phase 4 to graduate will tell me, Judge, I got too much now to lose if I go back to my old lifestyle. Because of the fact that now I do have custody of my kids and I'm responsible for my kids. I have a great job. I got a good place to live. And so I think that's the benefit of programs like this, is that we're giving people the tools to be able to survive in the community and stay out of the court system.
Thank you, Judge. If you've ever had the opportunity to go to a TIES graduation, I mean, it's pulls on your heartstrings, for one, because of the stories that you hear, right? But also it allows you to see the success of the program and programs like that, we have people that aren't just being thrown away, but people who are just really becoming amazing citizens and have an amazing story to pass on to bring others along with them. So appreciate that program.
May I have your attention,
Yes.
please, with the owner of the gray Chevy Malibu parked in the handicap
Oh, that's me. No, I'm just kidding. Right. All right. So speaking of those specialty programs, so that help with folk, I'd like to move down to Judge Munson, and she's has an amazing RISE program, and also a new program coming along.
Yes, thank you. First, when I took the bench in 20, one of the first things I did was work to create the RISE docket, which stands for Reaching Individual Success Every Day. It's a very similar format to what Judge McIntosh does, but it's folks who the mental health is contributing to their continued involvement in the justice system. Folks who, for the most part, wouldn't be here if they could manage their mental health, and of course all the attendant things that come with that: housing and co-occurring substance use, employment, all of those things. I am also in the process of, it's a program now, a pilot program, but we hope to create it, a specialty docket out of it. It's called the Renew program, and that is going to be a reentry docket, and that's for folks coming out of the institution on judicial release, coming back into the community. We'll have the same model that Judge McIntosh and I are using, specialty dockets in general use. And because we know that reentry from the institution to the community is one of the most critical phases. And, everyone is happy that someone's coming home from prison, but if you don't have the support in place, they cannot be successful in the community. There's so much anxiety if you talk to these folks about coming home. How do I get to a job? Where do I live? And just the different environment of having been incarcerated. We have some people in the program now who've done 18 years in prison, and now they're coming home, and it's a different world. And so we want to support them. And I want to talk about the RISE docket. I think the best way to talk about these specialty dockets is to talk about their successes, but I'm going to ask Dustin if I have his permission to talk about him. All right. So before I say anything else, let me say thank you to CBCF. The Community-Based Correction Facility has worked so closely with our specialty dockets. They brought these young men here today because they deserve to be in these spaces, and we want them to be comfortable in these spaces. They don't belong in jail. They don't belong in prison. They belong in the community, and if we support them, that's where they will be. Having said that, thank you to CBCF. This gentleman right here, this is a perfect example. When Dustin joined my RISE docket, he was sitting as a resident of CBCF. He was coming, you were in cuffs at the time in the beginning. He came from phase 1 in cuffs into my program. And now he just graduated from the RISE docket. He now works for CBCF. He is now, yes. He is now gainfully employed. And, what better person to do that than to be having been there himself and then giving back. And not only that, he has a heart of gold. He works with the Dream Center. He's in the community cutting hair. He fundraised and went out to L.A., volunteered at the Dream Center there, volunteered on Skid Row. He now has his name on a lease, on his own apartment, and a healthy, wonderful relationship with a wonderful woman, and he has a whole new life. And it's to his credit that he has that life, right? We can give you the resources, but you've got to grab them, and you have to have the fortitude to make it. So I think we can talk about specialty dockets all day long. Theoretically, all you have to do is look at Dustin Starkey to know that these dockets work.
Thank you, Judge. And that's what I'm talking about, right? When we hear the stories, that makes such a difference on the success of these specialty dockets that do make a difference in so many lives. So let me switch gears here a little bit, because sometimes you don't know what happens when a felony is filed. So if one of the judges would like to talk about, can you walk us through what happens from the time a felony case is filed until it reaches resolution in your courtroom? What steps happen? What do we know that happens on that?
It's a process. So the first thing that happens is someone gets arrested, then an indictment could come right away or it could come later, because if it involves a gun or if it involves drugs, they have to test those to make sure that they are what they think they are. So a lot of times from the initial arrest to the indictment, it can be some time. So once it's indicted in our jurisdiction, in our court, then an arraignment is held. And then after the arraignment, a judge is assigned. And so when it gets on my docket, I have it set up so that within 30 days after arraignment, after it's assigned to me, we'll get our first court date. I have all my court dates listed as trial dates. Some judges have pre-trials. I just call them all trial dates. It doesn't mean they're going to go to trial every single time, but that just keeps the case moving. So once it gets to me, then the attorneys, the prosecutor's office, and whoever is defending that individual, this is all criminal, of course. We can talk about civil if anybody cares. We'll just talk about criminal now. And so then then the first court date will come. I typically talk to the parties, making sure that they've been meeting with their client, making sure the prosecutor has provided discovery, which is the evidence, to the defense counsel so they can start working the case. I make everybody come back every 30 days and sometimes sooner. Because of the fact that if someone is actually being held in the jail and they can't make bond, I want to make sure that both the prosecutor and the defense attorney are working to make sure that we're either going to get to a trial date or we're going to get to some resolution that can get that individual potentially out of jail sooner. In the process, we'll have bond hearings if necessary. We will have, if there's motions filed, there'll sometimes be motions in motion hearings. And then it gets to a point, and depending on what type of case, that's why the age of cases can vary greatly, because obviously if it's a homicide, there's going to be a lot more evidence, and it takes a lot longer for the parties to know whether something needs a trial or if it's going to resolve in some other manner. If it's something low level, I keep their feet in the fire, because let's just move this along. The evidence isn't as large. So once it comes to a point where the prosecutor makes an offer, then the defense attorney will usually get time to discuss that with their client. I'll set another court date rather quickly so that we can either have a plea, a dismissal, or we'll set it for a firm trial date. So depending on if it's an F4 or 5, I prefer to get them done in 6 months, but it's usually 9 months or longer. And if it's a homicide, it can take up to 2 years to resolve because of the amount. If you just think about every officer is wearing body cam, they have to get all that, review it, and it's quite extensive amount of discovery now that electronics are everywhere.
Just a couple of things real quick with regard to the process. When someone gets charged with a felony, they start over in the municipal court, and they have an initial appearance before one of the municipal judges, and that's the first time where decisions are being made whether that person is going to remain in jail or get a chance out in the community. And obviously there's a lot of factors that go into that, the seriousness of the offense, their criminal record, how often they have failed to show up in court. And so a lot of family members get confused sometimes that the person gets charged. At some point in time, you may hear the term that it gets dismissed either for a future indictment or it gets dismissed over in municipal court because the person has been indicted. So it gets transferred from the municipal court over to the common pleas court, and then they have an arraignment where they enter a plea of not guilty, and then the issue of their bond comes up again. This is only important because in the serious offenses, we're likely to impose a fairly hefty bond. You know, if it's a murder, they're probably looking at $500,000 to $1 million bond. It's not likely that that person's going to be getting out. But decisions are made at that point in time, particularly for a lot of the lower level people that we deal with. What is their living situation like? Again, if there's someone that has failed to come to court on multiple occasions, like Judge Page indicated. And so we're looking at, or the court's looking at all of those kind of factors. And there are some resources that we try to utilize. Electronic monitoring, they're at home, but they're being monitored by the probation department. If we can, assessments for drug or alcohol treatment, or things of that sort. But it's extremely important that people understand, at least at those two phases, and it can happen up in my courtroom, where considerations are being made as to whether this person is going to remain in jail till their case gets resolved, or there are opportunities for us to put them out in the community while their case is pending. And that goes a long way many times as to how those cases get resolved.
So I want to piggyback a little bit on what Judge McIntosh said, because I do think in some situations, this is where I find there may be a large misunderstanding about the process. So we talk about arraignment and we talk about bond. And basically bond is your promise to come back to court and the conditions under which you would leave court while you're waiting for your trial. I think what a lot of folks hear, at least the discussions I hear, are when somebody's given a bond in the municipal court and then they post it and they make bail and they're out. You'll hear a lot of conversations, or they get a bond here in our court and they post it and they're out. A lot of folks will then talk about, well, that was a slap on the wrist. They're not getting punished. And I frequently have to remind folks that when it comes to the issue of bond, we're not talking about punishment. Punishment doesn't happen unless and until there's a conviction. And a conviction only happens if there's a plea or if there's a trial in which there's a finding of guilt. What the bond is what do we do with somebody who's been charged with a crime before we're able to have that trial? And I think it's important to remember that everybody's entitled to bond. That is a constitutionally protected right, both under our federal constitution and under our state constitution. So the idea of why do they give somebody bond? Because we have to. It's a constitutional requirement. Now, there are certain situations when an offense is so serious, the evidence against the individual is so great, they possess a very particularized a danger to either a particular person or to the public if they're released, or we have situations where they violated previous bonds, conditions of bond that have been given them. We can't hold somebody without bond, but that needs to be the exception, not the norm, because the norm is that constitutional guarantee. And I think what happens is when somebody reads an article about somebody is charged with X and they're out on bond, and then people assume that that's the end of the matter. And that's just the beginning. That is not punishment. No decisions have been made. That is the court deciding whether like I said, I wouldn't say it's not whether it's okay to let them out, because again, we have to let somebody out pre-trial most of the time. And the question is when we craft these bonds with ankle monitors or home confinement or drug testing or reporting, what we're basically doing is trying to tether this person to the court and to the process with the least restrictive means we can, so that we still protect what the state's interests are. They don't want this person to be a danger to the public or to any particular person. They want to make sure, and we want to make sure the person shows up and doesn't in other ways try to affect the judicial process. And so I really want to point out that all happens at the very beginning. And I think a lot of the way it's covered is because the beginning of a case is exciting. The filing of charges, the hearing of the story, the arraignment. It's all exciting because it's new. And then once arraignment's over, we watch as the public interest wanes in a particular case. And at the end of the day, the case ultimately resolves either in a dismissal or acquittal, and that's when a jury says not guilty, or a plea to a crime, or to a trial in which a jury comes back, or a judge, if it's a bench trial, makes a finding of guilt. That happens at the end. That is the end of the process for at least us at the trial level. Now, we could talk about our process never really ends, because sometimes we put a lot of people on community control, which is what most folks call probation. That's a different set, because now we have somebody who has been convicted. They're no longer a defendant. They're technically an offender. That's the word the statutes use. But that's where we talk about probation. What kind of rehabilitative treatment, what kind of programming can this person need? How can we assist them? And that's where we get more into that rehabilitative effort, but that's after sentencing. But when we talk about cases stem to stern, they basically start with that indictment or the original arrest. But for us, starts with the indictment and it ends with dismissal, acquittal, plea, or a conviction with a jury finding.
Now you talk about bond. So you might hear, they got $1 million bond. Or so does the person or their family have to come up with $1 million or $500,000 or whatever that bond is?
Well, it would depend on what kind of bond it is. If it's a cash surety, you come up with 10%. Typically, people post their bond with a bondsman, and that bondsman, it's basically an insurance policy, just because I used to work with bondsmen a lot when I did criminal defense. So basically, it's insurance policy. So you pay 10% to the bondsman. They go and give the court, if say you have a $100,000 bond, they're going to want $10,000, and then they give the court an insurance policy for that whole $100,000. Depending on what kind it is. Our court, cash surety or appearance, the only time you have to post it all is if you want to walk $100,000 into the clerk's office and give that to them to post an appearance bond. And rarely does that happen. Nobody wants to do that because you don't want to put out that money, because if that person doesn't come back to court, you have lost your money. That's the purpose of the bond. So most people go through, unless it's so if you get a $5,000 appearance bond or cash surety appearance bond, you could go in and post it yourself for $500. There's always, in Franklin County, we always put recognizance bonds on, which means you do not pay. You are signing something saying you're going to come back to court. And the reason for that is because if you fail to appear, the law says if you fail to appear on a recognizance bond, then they can charge you with failure to appear. So it's a little added guarantee without making somebody pay.
Okay. So along that same lines, what have all of you found to be the biggest misconceptions that the public has about the judges or the judicial process? What do you hear that's like, wait a minute, no, that's totally wrong. Let me explain this to you.
Looks like they're making me start. But I would say just this idea that we are disconnected from the people who stand in front of us, and that we wake up in the morning and we're like, who can I send to prison today? Those aren't the type of thoughts that we have. I am very proud and honored to serve with this bench in Franklin County, because I think we view people not just at that particular moment in time in which you're standing in front of us, but we do the best that we can to take into consideration what led up to that incident, and then what are the opportunities for you to make changes in the future. We have different avenues that we can use. It could be a specialty docket. For some people, the most severe consequence is prison. But that isn't something that we're doing joyfully or happily. We don't go have steak dinners after, that happens. We are just looking at what decision do we have to make, not only for the community, but hopefully for that person to make better decisions in the future.
So for me, I would say I think the biggest misconception is the level of power people think we have. So you walk into a courtroom, and it's an impressive looking courtroom, and it's meant to be that way by design. We wear these black robes, we sit up higher on our dais, and that's, again, all by design. But I think sometimes it goes a little farther, and people think that we have extra power. We don't make law. We can't we don't just look at somebody, listen to their case, decide, from whole cloth what we want to do with that person or how we can help that person or what resources we have. What I typically do is I think every time somebody comes into our courtroom, there is some level of dispute. Either it's the state versus citizen in a criminal matter that the state is alleging this person committed a crime, or it's a civil dispute. It's two parties think you've done me wrong on a contract, I slipped and fell in your building, we were in a car accident together and I think you should pay. It's a dispute. And they come to us because we, as the judges, are what we're supposed to be is neutral arbiters. And so people come to me and they ask me, Judge, I want something. If it's a lawsuit, Judge, I want this person to pay me $5,000 because that's how much I was damaged in this car accident. The state comes to us, Judge, I want to convict this person. I want to punish this person for having a weapon while under disability because that is a crime. And so I always tend to ask myself, what is it that you're asking from us? What is my authority to grant the relief being requested? Where is it in the law that says I as a judge can do this? And then that establishes what I call the standard of decision. Here's a set of laws that say, oh, you're facing this. Well, English and American legal system's been around for about 600 years. So we've had plenty of opportunities to see all the different ways we can dispute each other as human beings. So a lot of times we'll go to the law, it's already covered this, and it'll tell you in this situation, these are the things you should look for. These are the elements that need to be addressed. These are the factors that need to be weighed. And that is where our decisions come from. we aren't sitting up there just making it up. We really have a lot of guidance from, like I said, about 600 years of jurisprudence that's preceded us, and we follow that. I do think that a lot of folks tend to think that when we're up there on the bench, we can almost do anything we want with a case, but we can be creative for sure. We have a lot of discretion. The law gives us a lot of leeway and a lot of flexibility to address needs of individuals, but we still follow that law. And I would argue that sometimes that's the tragic part of it. Maybe we disagree with the law, but we still have to follow it. And so maybe we see something in a defendant in front of us that we think could benefit this person. Maybe we don't want to send this person to prison, but the particular charge that they are pleading to comes with mandatory time. We can't break the law to get to the result we would like. What we try to do is see if we can get where everybody needs to go within the law as it exists. So I would say that's the biggest misconception, is the fact that we have a lot of power as judges because our decisions about what the law says and how it applies, I mean, obviously we're here at the trial level, but then it goes to Court of Appeals and then to Supreme Court. But that's the final word. The judges are the final word on how the law applies, what the law means. But because we have so much power in that regard, the instances in which we can wield it are very limited. And I think that's probably the biggest misconception, I think.
And I just want to piggyback on that a little bit. Again, I agree that in terms of the public thinking about the judge's role and the power that the judge has, so many times in criminal cases, really, when it comes to plea bargaining and those sorts of things, it's really the state of Ohio as the prosecutor in the case that's making those offers. So many times you'll have someone come in and ask, essentially, I don't want to plead to this, judge. Is there something else I could plead to? Or can you dismiss this case? And we can't do that. For instance, we can say you have a right to try this case, but we are not making the offers in the case. So as Judge Miller said, if the prosecutor is only offering a plea bargain that attaches mandatory time, and that's what you decide as a criminal defendant with your lawyer is the best course of action, our hands are tied. There will be mandatory time. And so many times it kind of amazes me that we will get all the way to a sentencing and you'll still have a criminal defendant or a victim in the case asking you to do something that is excluded by the plea agreement that's already been made. And I think that comes from this idea that you're the judge, you can do whatever you want to do. But effectively, again, as to what Judge Miller said, we have to follow the law. And so many times in criminal cases, it's the state of Ohio that's making offers, and then ultimately the defendant is going to have to decide, are they going to accept the state's offer, or are they going to go to trial? And then the judge is sentencing, pursuant to whatever that offer or that conviction, whatever those penalties are allowed under the statute.
Okay, I agree with what everyone else said with regard to misconceptions, but also I think a big misconception is what does our probation department do? So many people, particularly when I first got on the bench, I got the sense that they thought I was putting them on probation so that the probation officer could come up with a reason to send them to prison. And that is not the case at all. And our probation department has gone over the years that I've been in the bench, a huge change. It was a little bit more law enforcement based, but it really now is very much social work based, because the probation officers do a lot of cognitive behavior with the people that are in front of them. They're sitting down, having them work through problems, getting them to think about why they're doing the things that they've done in the past and what the future may be able to look like for them. So the probation department really is trying to address the needs of the individuals that are coming in front of them, and would love nothing more than to be able to address those needs and have the person go back into the community, and would see it as a failure that this person unfortunately is now before me, and I am shipping them off to prison. So I really think that the perception of what probation looks like, and again, we call it community control, is totally different than what a lot of people think.
Well, good segue though. That actually goes to, I think, our chief probation officer over there that can expand on that a little bit about what they're doing over there, rather than not dinging people, but making a difference.
Well, thank you, Judge. Very true. I can tell you all here today that when I took my office chair in 1995, probation looked a lot different. And it was gathering violations and arresting people and figuring out how to put them in jail. And that is just simply not the case. So in today's day and age, since really 2016-17, we started working on this project, and we've completely changed our probation model. We do full-scale assessments on everybody that comes through, whether it be pretrial, and then if there's a plea and they're placed on probation, they come to our intake department and they undergo an ORAS assessment. Now, what's the ORAS? A higher risk assessment system. It is merely a risk of recidivism. It is not a psychosocial assessment. So it's risk of reoffending. And we do behavioral health trailer tools for mental health and substance abuse, and then they are assigned to a probation officer while they're there on that sentencing day. Our intake department, Lauren, is awesome. They will assign an office visit for the individual, and they will meet with their probation officer to go over an individualized case plan, which will entail, what are your need areas? Is it substance abuse? Is it mental health? Is it housing? Is it transportation? Is it childcare? All of it. And we meet the people where they're at and try to develop a case plan that will effectively help them and ultimately reduce reoffending. We talk a lot about, what was your decision-making process in the past? How did that affect your short and long-term goals? What could you do differently the next time this situation happens to you? And then hope that there are different decisions made moving forward. We are not looking to arrest everybody that comes through our doors. I can tell you that in the 90s and early 2000s, we probably did 50, 60 arrests a month. I think we do 14 or 15 now. Our department works very hard to link people with community-based providers who will assist them, peers. Justin, thank you. And the Common Pleas Court judges and the commissioners of Franklin County, we work also with the City of Columbus Office of Violence Prevention. Everybody is interested in having a safer community, and they allow us the opportunity to do that. Are we perfect? No, but really, that's probation.
All right. Thank you, Chief Wunderlich. Okay. We've got a lot of great questions that are coming in. I'm going to try to get to all of them. I probably won't, so bear with me on this. And then also, if by chance, you came in late or whatever, this will be loaded up onto our YouTube channel. So we do have YouTube, and we do have Facebook, and we do have LinkedIn. So I expect to see everybody on your phones at some point, friending, following us, and liking us on all of the social media. So that you can find out more about this, not only this program, but others that we have, because we will be doing this also on the north side of town and on the east side of town. So we're purposely going out to making sure that we can connect with people from all around Franklin County. So one of the questions that came in was asking about how do you determine the time someone gets for a drug case? Does it make a difference if it's 50 pounds, 100 pounds, or what all goes into, how do you determine on a drug case,
First, yes, it does turn largely upon the amount and the type. We have talked a few times about different levels of felonies. We say felony 4, felony 5, felony 3, and I need to make sure you all understand, because a lot of folks, sometimes we forget that most folks don't understand this. So felonies are graded from the lowest level felony, which is felony 5, fifth degree felony. Felony 4, a little bit higher, 3, 2, 1. And then the highest level felonies are what we call unclassified felonies. They would be your murder charges. But yeah, the amount or type of a particular drug in a drug case, a possession case, yeah, that will determine what is the severity of the crime with which you're charged, and then plea agreements or discussions or trial will determine what level of crime you are ultimately convicted of. Now, when it comes to, first of all, whether we send somebody to prison at all or not, we're given guidance. I think there was a recent decision from the 10th District Court of Appeals. I want to nerd everybody out, but it said our sentencing statutes are based on a expansive constellation of statutes, and I think that's a pretty good way to say it. There's a lot of statutes that give us a lot of guidance, but in general, it works like for lower level felonies, those 4s and 5s, all things being equal, there is a tendency for the statutes to lead us to community control or probation and away from prison. Felony 3 level drug statutes get interesting, and this is one of those areas where I'll point out again, we are required to follow the law whether we agree with it or not. And in the state of Ohio, for a felony 3 drug possession case, there is a presumption in favor of prison. The statutes say it's presumed that prison is the best way to meet the purposes and principles of felony sentencing for a felony 3 drug possession case. Now, a lot of us don't particularly care for that presumption, but we're required to apply it. It can be rebutted if we make a couple findings with respect to seriousness, with respect to recidivism, but so it can be overcome. But sometimes I find myself in a courtroom with a case where I just can't make that recidivism finding. Somebody has just way too many priors. And so now I have to make that choice to send this person to prison. Now we get to higher level felonies, felony 2, felony 1. That's maybe a more of a decision. But the first decision isn't to send somebody to prison. The first decision, or how much.
They're mandatory.
What?
F1s and F2s.
I haven't had an F1 and F2 for a good long while. Those 3s are where I have all my headaches. But the point is, well, I'll tell you that. And then when we get to a level where we have to impose prison, or we've decided that we should in this particular case, the statutes then also give us the range that we can give. So 1s are, 3 at a minimum, 11 to 16 and a half is a high. I'm not going to talk to you guys about Reagan Tokes and indefinite sentencing. Life gets extremely confusing. 3 to 11. Felony 2s are 2 to 8. Felony 3s, at least with respect to drugs, are 9 months to 36 months. Well, I thought, is there a drug one that goes 60? I thought those are the GSI and.
There's a drug.
All right. Well, and then lower level felonies. So the highest level, the highest time somebody could get for a felony 4 is 18 months. Felony 5 is 12 months. We have discretion within that range. Now, a lot of times, and going back to Judge Munson's point, this will all be worked out between the parties. The state and the defendant agree to a plea agreement, and that plea agreement comes with what's called a joint sentencing recommendation. Now, that means that if the plea is accepted and the defendant is found guilty, the parties will then recommend a sentence to the court. Now, we're not required to accept those recommendations, but I think most of us have a pretty solid tendency to. I do, and that's mostly because my thought is this. It is an adversarial process, and these 2 lawyers know far more about this case than I do. They've looked at the evidence. They've teased out and game theoried the case. They know what their strengths and their weaknesses are. They have a sense of the likelihood of success or the likelihood of failure. And they're not supposed to agree on much because they're adversaries. So if they come to me saying, hey, Judge, this is what we think the ultimate resolution of the case should be, then that's something I really need to take care of and listen to. The second reason I tend to follow joint sentencing recommendations is precisely because I'm not required to. If I ever deviate from a joint sentencing recommendation, I know that makes it that much harder for the next two attorneys to negotiate in front of me because I'm not going to be as predictable. So even though I can never abdicate my duty or responsibility, I can never promise that I'll always follow a joint sentencing recommendation. I do think I can let, and I think most of us do, let the attorneys know and the parties know, if you work this out amongst yourselves, we are most of the time, not always because we're not required to, but a lot of times we're going to respect the agreement that you've come to. When we're left of our own devices, we basically follow the statutes. We look at what is the range we're allowed to do. How serious was this conduct? You want to go? Drugs. That's right. Well, I was trying to come back to drugs as I go. The question is about drugs. So, how serious is the conduct? And I go, most possession cases are fairly the same. But then the question is typically recidivism. We look at somebody's record. How likely is this going to help them out? We try to help in drug cases because that is addiction, and that addiction's the driver. And if we can fix that, then great. That's what we want to do. I think for most of us, when we have to send somebody to prison on a pure possession drug case, where their only crime is possessing the drugs, we tend to err on the side of less is more.
Well, let me kind of piggyback on kind of the discussion that you were having, with the changing laws with technology, all that is going on right now. You got AI making an impact. How do all of you as judges, keep up with that? Do you have like a ticker tape that's happening, or what? How do you keep up with all that, and then to be able to then have somebody before you in court, and then having to change your mindset on how the law applies?
Judge Page? I was going to say I asked them, but we have what are called continuing legal education courses. So those are offered frequently by the Ohio Supreme Court and other institutions that keep judges trained and up to breast on the changes in law. We will read appellate court decisions. We received information, again, that just kind of tells us what legislation is changing. So there are a lot of different resources for us that give us the information to let us know about the changes in law. The law is constantly changing. We have a very active General Assembly here. So I will say that there's no judge who will know all of the laws and all of the recent changes, but we do the best that we can to ensure that we are gathering the information. So when that particular issue comes before us, we are looking at the most current version of the law.
Okay. Anybody else? All right.
We also rely on the attorneys.
All right. Sounds good. So, thank you for that, Judge Page. One of the questions that came in is in regards to the RISE and the RENEW programs. How many people? Because I know you talked about the RENEW just getting started, but how many successes have you had with the RISE program?
So,
and how long does it last?
okay. So the RISE program, that's a 4-phase program. Ideally, it was designed for folks to complete it in 2 years. But again, it's very individualized. If you are hitting the marks and moving through the phases, you're going to graduate perhaps earlier than somebody else. The RENEW program, which is the reentry program, is 1 year to 18 months. Again, these folks are coming out of the institution. There may be some mental health implications, substance use implications, but really, I think probably lower levels of care are needed for those folks, and so we want to advance them. We want to make sure they have housing. We want to make sure they're employed. They have resources. If they need that mental health care or that substance use care, they're getting that. So the reentry docket is designed to be a little bit shorter than the RISE docket. And in terms of success cases, I could certainly talk about graduations. We graduate on average about, I would say, 3 or 4 individuals. I think we've done 3 or 4, Faith, 4 graduations. We have not graduated anyone from RENEW yet. But the one thing I want to point out, and this is very important to me, when we talk about successes, not everybody is going to succeed in the same way. So we have folks on the mental health docket that are very sick individuals, and we have a lot of folks with traumatic brain injury, and so there are limitations to where the marks they're going to meet, right? So if they are, stably housed, if they are not abusing drugs that are not prescribed to them, if they're taking their medication, if they're in pro-social relationships and they're not reoffending, then, that's what success looks like for that individual. Then you have other superstars like Dustin Starkey, who becomes the poster child for your docket. But there are other folks, with more limitations that are working just as hard as Dustin and may never be in the same seat as Dustin, but they're still a success. And so it's very important when we interact with our participants to let them know to, first of all, celebrate every success they have. And second of all, let them know that, your success might not look like the person sitting next to you, but you are still as valuable, it's still as meaningful, and you should still be as proud of yourself. So success is a variant, but I will tell you this, when you look in general and of folks recidivating or reoffending, the folks on those dockets, especially dockets, are reoffending at much lower rates. Though, our probation department obviously does an amazing job, and people, they're keeping those rates down too. But especially docket rates, at least what I see in my courtroom, those recidivism rates are lower.
Yeah, and Judge McIntosh, could you speak to the TIES program on that? Same question.
I will. But just real quick, in the TIES program, we're limited to 50 participants, but we're generally right around 30 to 35. Because again, the population that we're dealing with are the people that have been through the system multiple times, many of them in and out of prison multiple times, in and out of treatment multiple times. So we feel good when we're graduating 5 to 7 people at a graduation based upon the number that we have on our docket, specifically for TIES. So it would not work for everyone. I mean, someone that is a new drug user, what we have is too much for them. Someone that has been through the system multiple times, what we have is exactly what they need. So we have 2 graduations a year, and like I said, we're very pleased if we're having anywhere between 5 to 7 graduates during that window of time.
Great, thank you, sir. Moving to one of the questions. So it's in regards to electronic monitoring, and maybe, Chief, you'll be able to answer this. Can you identify everywhere a person goes with electronic monitoring, and what happens if they leave home?
Yes, we can tell where someone is. If the device is charged, we can locate the individual. The parameters of electronic monitoring are different for release. So it might be that you have electronic monitoring and you're on home confinement and you can't go anywhere. It might be that you're on electronic monitoring and you can go wherever you want, whenever you want, but we know where you are. And it might be you're on electronic monitoring and you're not allowed to go in certain areas. So, yes, we do know where the monitor is, and hopefully it's attached to a person. But we don't share that information. That is only for the court and for us. If someone called in, including the victim, we would not tell them that. If there's anything to do with victim notification, our prosecutor's office thankfully handles that. But yes, we know where they are, and there are a lot of options with electronic monitoring.
All right. Thank you, Chief.
We also know when they're cut off. I just want to make sure you know when they're not with the person they're supposed to be. We know that too.
All right, very good. One of the other questions that came in, what if you're on probation with a felony and also with a misdemeanor? Who do you listen to if both demand different things?
Can you hear me? All right. Ideally, so and I know, and other judges probably have similar philosophies. We try not to duplicate the efforts. If you're reporting to a municipal probation officer and to a felony probation officer, it's not good for anybody to be duplicating efforts. It's not fair to our probation department, to municipal probation department. So sometimes, for instance, if I have somebody who's been on municipal probation a while and they're very invested in whatever programming is going on there, I might simply say, I want you to do these things, but mostly I want you to comply with your municipal probation. And then likewise, if they're getting on about the same time, I think mostly common pleas, felony probation is kind of dictating the things that they're doing. But it's really, at least for me, and I'll let other people speak, nobody should be down here doing the same things over and over again. Because first of all, if you put too much on an individual and they become overwhelmed, then they're not going to participate. And then they fall out of this, compliance, and that does no one any good. But I try to accommodate that.
I think commonly what we see a lot of is someone is driving a car under the influence and they get stopped and then they get caught with either drugs or a gun. And so the OVI part goes through municipal court much quicker, and then they get indicted, and they're already on the right track. And so what I would do in that situation is if they're doing well in municipal court, I would probably put them on non-reporting in felony court with the conditions, no more convictions, and abide by all the terms of your municipal probation. And that way they're not overworked, but if they screw up, then they're going to come back to me, and then we'll deal with if they're not getting what they need or if they need something more. I try never to put people on, if they're on federal paper and then they get on state paper, I try not to make them do 2 probations or 2 different counties or any of those things, because like Judge Munson said, 1, it's wasting resources, and 2, it's too much. And we want you to be successful. We're not just trying to pile on you.
I would just add briefly that if you know of someone who is being monitored by 2 different courts, they can't choose. So you can't say the felony judge is more important than the municipal court judge, so I'm only going to listen to my felony court probation officer, because regardless of what it is, the probation officer, they operate as an arm of the court, and your probation or your parole could get revoked. So if someone is in unfortunate circumstances where they are reporting to multiple probation officers, just encourage them to continue to go so and raise that concern with their attorney.
Okay. Anybody else? Okay. So we had talked about briefly technology and things that are changing so quickly in our ethos around the world with AI, et cetera, et cetera. But one thing that the court has done was improved the technology within the court. And I'm sure you've seen that, especially with some of the court cases are live streamed. So if we could have our IT director over there, Andrew Byerly, kind of speak on the things that have been done to better prepare for you, the viewing audience, but also for those who are attending in court.
Well, good evening. Some of the things that we have been working on have a lot to do with ADA compliance and the requirements that have come from the federal level. And so some of those, just to at least educate some of you that are here, a lot of the county and the state and even at the federal level, the governments are required to make some changes to how we provide information to the public. And so of some of those changes that you'll see is when we do live streams, our live streams will now include closed caption. So for those who have challenges with hearing, those closed captions are available. And if you're not aware, a lot of our judges will choose to live stream some of their trials, and that's available on our websites. So you can see and watch the trial a lot of times all the way from beginning to end. Another change that we've been implementing because of the ADA compliance requirements is accessibility just on our website. A lot of times with governments, you have small budgets, you have just trying to get the work done because you're battling lots of other priorities. So sometimes websites aren't designed in such a way that they can be consumed by everybody. And so part of these compliance requirements are to meet a certain standard. So my team, for about the last year, we have been educating ourselves on what are these requirements, what do we need to make changes to, and there are some absolutely amazing tools that are available to web developers. And just this past week, I was working on one of these, and they're called stimulizers. But what they are is they're extensions that will show you what it looks like if you're dyslexic, or if you're colorblind, or if you're using a screen reader. So these are tools that we can apply as on the technology side to help us design these websites or information that's consumed by the public in such a way that it's more accessible. Another thing we actually just implemented this week is a tool that for all of our PDF documents. In governments, we love PDF documents. We create them, we put them out there for the public to read. But this tool actually reads PDF documents and it translates it into HTML and in a format that it can be consumed by screen readers. So for folks who need to rely on a screen reader to read PDF documents, not just websites, but also PDF documents. And so countywide, you'll start to see a lot of this implementation happen, but most all of this is because of these new ADA requirements. We also have assisted hearing devices inside of the courtroom. So if you are a participant, if you're on jury, participating as a juror, or even a defendant who needs some assisted hearing devices, we have those in the courtroom. They're headsets. We also have neck loops that you can connect to hearing aids. And this is absolutely amazing technology that exists. And really, we've implemented and upgraded these things probably in the last 5 to 7 years, just moving further and further along with technology. And our focus, at least on the technology side, is to focus on accessibility and just making sure that these tools that are now available, that we try to integrate them into our courtrooms.
Excellent.
And just a real quick example. On Friday of this week, I have a sentencing on a murder case. On Monday or Tuesday, my bailiff approached me and said that the victim's family, many of them could not make it on Friday to the sentencing. Could we live stream the sentencing, which is what we're going to do, so that the victim's family members who cannot make it to court at least can be present for the sentencing that takes place. And I think all of us use those kind of tools to accommodate people who may have difficulty coming down to the courthouse.
Excellent. All about accessibility. So definitely appreciate that. One last question. I'm sorry I didn't get to, there's some I still didn't get to, and we're running out of time, but I do want to, when we bring the judges out and we do these throughout the county, I always want to think about the impact on the judges, going to court cases and going up, and seeing sometimes the worst of worst, and how you deal with that. So if I could just, ask each of you, how do you deal with what comes before you day after day and not be somewhat depressed or what have you? How do you keep that from impacting who you are?
I'll be quite frank. I think that it's not for everybody. I think there are people that it would be a challenge to do the work, and I think that the people you see before you did other work ahead of time that in some ways perhaps exposed them to that. Obviously, I was a trial attorney, Judge Phipps was a trial attorney, Judge McIntosh, all of these folks here have experience that have exposed them to some of those things. And so you learned that you were in a position you felt to cope with it and still be objective. The most important thing to me as a judge, I believe, is to never take anything personally that's happening, because then you're acting out of your ego and rather than acting in the best interest of the people in front of you. So while you hear horrific facts that might upset you very much, if you are so incensed at that moment, I mean, I will quite frankly say, I'm going to step back, or I could continue this case 2 weeks because I'm not going to make a decision out of anger or horror or whatever it is that I see in front of me. So, it's a certain level of emotional intelligence that I think you develop. And at the bottom of it all is that I think fundamentally everyone you see here comes from a place of compassion. And if you have, compassion in your heart, I think that protects you from even seeing the worst things that you see, because you have a job to do, and your job is to help those other folks and to serve them. And if you just could look at yourself in the mirror and say, I did the best could do today and made the best decision I think I could make today, then you can go to sleep and live with yourself.
I would totally agree with everything Judge Munson said. Coming from the defense aspect, when it comes to the most horrible crimes, I used to sit next to those people. I used to help them through either their biggest mistake or whatever happened in their life that got them to that point. And I know everybody who gets arrested is a human being. And nobody chooses nobody says, I'm going to go out and become a drug addict and then shoot somebody in the face. No, nobody grows up with those plans. Bad things happen, and people are exposed to things that they should never be exposed to, and it does form you. And I realize that no matter what someone did, when they stand before me and I hear facts that either make me want to cry or make me nauseous because they're hurting children or whatever it is, I have to take into consideration that they are a human being, and the person that is standing before me deserves to be treated with all that respect. And it is not for me to take it personally. And only twice since I've been on the bench have I had to look at somebody who's being so disrespectful, and probably out of panic and out of worry and out of concern for what's about to happen to them, that I've had to say, I'm going to take 2 weeks, and I'm going to go when I'm not angry because of the way you're choosing to speak to me, and I'm going to come back and make a decision on a different day. And I just want, part of what nobody said when it came to what do people in the public not understand about us, we don't make decisions lightly. I take a week before I have to see somebody and sentence them, a whole week to think about and study all the information I have. We don't take anything we do lightly, and sometimes we go home and we are heartbroken about the decisions we have to make, and it does weigh on us. But guess what? I can't think of someone better who could do the job than someone who actually cares about every human being that comes before me, because everybody deserves to be cared about. When I did defense work, I represented, one of the most heartbreaking is when a child kills another child. And I'm sitting with this young man who goes to trial on his case, and he's not even an adult yet. He is not 18 years old, and he's going to trial for killing another child. And one of the things he said to me will never leave me. And I keep it in my heart, and I keep it in my head all the time, is he goes, Miss Karen, all I wanted was for one person to stand up for me. That's never happened before. And that puts me in the right place, in a row making decisions.
Okay. What brings me back to work every day are the successes. It really is. The people that we're able to make a difference in their lives. I tell people all the time, I have a job that gives me an opportunity every single day to make a difference in someone's life. I may not always do that, but just having a job that gives you that opportunity to make that difference brings me back every single day. But yes, we do see some terrible things, some awful things. That is, yes, part of the job. But first of all, it's the successes, and then my faith and my family. I absolutely need both of those. I need to pray because I don't do this job by myself. I can only do this with that strength. but then also having a family to come home to that I can talk about anything other than my job helps me as well. But the thing that keeps me coming back that I really enjoy about the job are the successes that I have the opportunity to see each and every day.
So at this point, I'm going to echo a lot of what you've already heard. I think it's true. We see some very horrible things from time to time. And the weight of the decisions that all of us have to make, and all of us do make, do stick with us. I personally think I try to intellectualize it, but you can't do this entirely with your head. You still need the heart to point you in those directions. But I do think it is those successes, that individual that you see has turned their life around, that getting thanked sometimes for putting somebody on probation, sending someone to CBCF, watching them, and it's not just the gratitude, like I feel good that I'm being thanked, but they're in a position where they can thank anybody. They have turned their lives around. That is a success story. I wish they happen more than they do. They don't happen enough, but I think we have a pretty good, I'm happy with the way our probation department works, the way the resources we have, so we do get those moments, and I think we get them frequently enough that it doesn't let us get dragged down by the weight of everything else. But you will, from time to time, go through a stretch where it's nothing but bad. And then that welcoming moment, that one success story will come in. And it even if it comes once in only a rare while, it tends to be enough to carry you through. So echoing everybody else, that's really how I get through.
Two things I try to keep in mind. One are that good people make bad decisions, and an overwhelming number of the people who stand before us are good people. Something happened on a particular day, or something happened in their life that led to them making that decision. But I have friends and family who have stood before some of my colleagues, who have stood before other judges, and I know that they are genuinely good people, but they made a bad decision on a day. And so I don't hold that against those who stand before me. I don't hold that against people who are convicted of an offense. And I try to always remember that could be my brother, that could be my sister, that could be my uncle, that could be my dad, and that we need to do the best that we can as a system to wrap our arms around them. Again, we have severe consequences, but in those consequences, we are just hopeful that that bad decision that good person made doesn't happen again.
Well, first of all, everything they said is correct. I just wanted to shout out to our probation officers because the secondary trauma is real. And you have someone in your caseload for 5 years and you see them every 2 weeks. You know pretty much everything. And so you need to take care of yourselves as officers and as judges. Talk to your therapist, talk to your dog, whatever it may be, but it's real. And it's sometimes challenging, but like they said, when you have somebody calling you on their sobriety date every year, it's a good thing.
I want to thank the court administration so much because when you're on the bench in the moment making these decisions, the fact that some people in the background are making everything else work it's one more thing that you don't have to think about. We have great administrative judges, presiding judges, but could you stand up and our administration stand up? Everybody, yeah. Yes, because seriously, the courthouse does not run without these folks. And they, again, I sit on the bench and I don't worry, will there be jurors downstairs if I need jurors on a trial, because administration takes care of that. I don't worry, if I need my technology, because if I need help, which I need help a lot on my technology, they are there to take care of it immediately. So there's so much going on in the background that it makes it much easier for us to do our jobs because they do all of the hard work.
No, I can retire in like 6 months. So I just want the community to know that like these judges are real. This county is so lucky. I am a part of the Chiefs Association, and some of the horror stories that I hear are just appalling. So your court has your back, the commissioners, the city of Columbus, the public defender. Everyone is working for a safer community, and they're trying to get help, or trying to help individuals succeed.
Just real quick, I've actually worked for the court for 32 years, and what keeps me coming back every day is the 5 of the judges sitting here, along with the rest of we have a total of 17 judges, but they are the most hardworking, genuine people that you will meet, and again, that is what keeps all of us coming back to the court and wanting to support in the way that we do.
Really appreciate the conversation and letting people into who you are, right? And we appreciate the audience here and the viewing audience here for being a part of this conversation. And we hope that it doesn't end today, that we continue these conversations because the more that we communicate with each other, and if there's some misunderstanding, let's talk about that because then we work through the issues, make things better for all of us. And as you see, we have some very engaged judges and administration and with the community because this could have been something that we says, well, let's go out to the community, and they're like, but they wanted to make sure this happened. They wanted to make sure, because often we can, talk about the community and this, that, and the other, but the difference is being in the community. That makes the difference because I say when we go out to the community, we break bread and we talk to people, take that time, then when people come before you, you kind of know their story, right? So I kudos to the judges, and yes, sir.
And so you ever have an interest to come down and see what we do.
Yeah, and they even have tours, right? Thanks for coming. Have a great week.